And we're still on that breaking story. Former President Jacob Zuma now being able to appeal a ruling on his medical parole. ENCA's Masego is following those, was following those proceedings, and she joins me now. She's been combing through that judgment that was set earlier on. So Masego, what did the President's legal team say about the wording of being terminally ill, a term that was thrown about quite a number of times during the proceedings this morning?
Well, I think that was a very important point, obviously, for the president as well as the former president as well as his medical, or rather his legal team. It was something that, during the judgment last week in the North Gauteng High Court was mentioned quite a bit by the judge. So I think that's why his legal team had a gripe with the wording in the judgment as well as the wording in the actual act. So I think it's important for me, Rapua, to just read this. I've got this piece of paper with me because I'm not a lawyer, and obviously, I try to interpret the law, but I think this is very self-explanatory. In terms of the Correctional Services Act, Rapua, medical parole can only be granted to an offender suffering from a terminal illness or condition. This is a quote. Or condition if such an offender is rendered physically incapacitated as a result of injury, disease or illness, so as to severely limit daily activity or inmate self-care. So I think this is what was being argued a lot by his legal team, especially Dalimpofu, but as well as the advocate Mpahlele, who was actually representing the Correctional Services Department in this case. Remember, they were also on Jacob Zuma's side in terms of what was happening in that case today. So here's where Section 75 and Section 79 also comes in, and the wording by the medical doctors when the application was made. Now, what the people who were opposing, or the organizations who were opposing this appeal today in the High Court in Pretoria was saying is that he applied for medical parole, and in his application he cited Section 79 of the Act. Right, and in Section 79, the difference there is that Section 75 says that the National Commissioner of Correctional Services can then come in and overrule whatever decision was made if the inmate spent less than 24 months in prison, or the sentence is 24 months or less. Now, obviously, the former president was sentenced to only 15 months in prison for contempt of court, so that then gave provision. So, the lawyers and semantics and different law, citing different acts of the law in terms of 79 and 75, whether it's normal parole or medical parole. Does this mean he was terminally ill? A lot of them saying that the doctors themselves from the SANDF said that his health is actually not deteriorating anymore. It has now started to improve. So they were saying that if his health is starting to improve, it means it's not terminal, right? It's not irreversible. So that means he can spend time in prison. But what was important from Advocate Dalimpofu, which the judge also said that was a very good argument, Rapua, and I think it's important. I know sometimes, by us as reporters or journalists trying to explain to the viewer, it's quite complex, especially because South Africa has not gone through such a case. It's the first time that we see a former president being sent to prison, a former democratic president at least, being sent to prison. So now what Dalimpofu was saying, Rapua, I think was very important. He says in the judgment by Judge Elias Matojane is that on page 29 of his judgment, he says, he writes extensively what the doctors, specifically a Dr. Mafa, said about the president, the former president, and how ill he is. And he cites a lot of quotes by Dr. Mafa saying that he's terminally ill, this is what's wrong, etc. But suddenly, in the same judgment, on paragraph 62, he changes and says there was not enough information in terms of what is wrong with the president and whether or not it's irreversible. So Dalimpofu was saying, what exactly are you saying? In the same judgment you say you have a lot of information, but later on in a later paragraph you say there was not enough information. But let's have a listen to Advocate Dalimpofu specifically on that argument.
Even if you look at literally, your Lordship says that, let's look at paragraph 29 of your Lordship's judgment. Your Lordship says, on the same day, 20 days after the third respondent was taken into custody, Dr. Mafa applied for medical parole on behalf of the third respondent. In the application, says Your Lordship, Dr. Mafa stated that the third respondent was suffering from a terminal disease or condition that is chronic and progressive. This is Your Lordship speaking. He says Dr. Mafa stated that the third respondent, Mr. Zuma, was suffering from a terminal disease or condition that is chronic or progressive. Those words are taken directly from Section 79. In other words, Dr. Mafa said that he is suffering from a terminal illness. However, yourself, the same judge at paragraph 62 says, Dr. Mafa, in completing the medical parole application, does not state that the third respondent suffers from a terminal disease or condition. So where are we? Does Dr. Mafa state that he suffers from a terminal condition, as Your Lordship correctly points out in paragraph 29, or does not, as Your Lordship, the same person, says at paragraph 62?
Indeed, a lot of complexities that have gone into this particular case, Masaho. I like what you said, saying it's the first of its kind where we're seeing a former president going through the courts as he has been over the last few years. But in this instance, what was important to note in what the judge had to say?
So in his judgment, Rapio, I think what was very important from the judge is that he says that the former president should be given some sympathy because he is old and he is frail, and we do know that he is ill. The semantics on whether or not he's terminally ill or if his health can deteriorate further or not is neither here nor there for now, but he believes that he should be given some sympathy because of his age and because we know that he is ill. He also said that he does think that perhaps another judge might come to a different conclusion in terms of the medical parole being granted and whether or not that was lawful. He says this is important because of that argument about Section 75, Section 79, and the wording of somebody being terminally ill, as well as the definition. So the judge today is saying that, there is some type of sympathy that he thinks the former president could be afforded, and he thinks that another judge, there is a huge possibility that another judge, because of that sympathy, might say that the former president doesn't have to spend time in prison anymore. And also he says that what's important is that the former president, that is Rapua, is not the one who granted himself medical parole. He simply applied because his doctors were telling him that he's getting worse. So it is for this reason also that he thinks that the case can go to the Supreme Court of Appeal. Here's the judge himself.
Without interrogating all the necessary information that was before the National Commissioner when the National Commissioner made the decision on whether to grant medical parole or not. And the Lordship was not even in possession of all that information, because there was some information that is with the South African Medical Health Services that was not before the National Commissioner. I mean, that was not before this honorable court. And the report, some of the reports were redacted. That was before the honorable court. And on that basis, the honorable court was not in a position to make an informed decision based on all the medical evidence that was before it, and was not even in a position to interrogate those because it didn't have them before itself. So therefore, the decision to substitute the decision of the National Commissioner with its own decision, we submitted this. It is a misdirection, my lord.
Yes, but Mr. Mpahlele, the Parole Advisory Board has all the reports, even unredacted reports, and it came to a conclusion that the third respondent does not meet. In my view, this matter merits the Supreme Court of Appeal's attention to bring certainty in the correct interpretation and application of these provisions. I'm also of the view that there is a reasonable possibility that another court may find that the order that the third respondent's time spent on medical parole should not count towards fulfilling his sentence, as this impacts on him unfairly in that, one, it was not his decision but that of the commissioner to be released on medical parole. Second, his meeting with his political allies and a prayer meeting was a once-off thing. His freedom of movement is restricted, and this has an impact on his dignity. He is serving his sentence, albeit outside prison. Third, because his illness and advanced age. What I want to say is because of his illness and advanced age, he needs compassion, he needs empathy and humaneness, which is the essence of Ubuntu. In my view, another court may take this into consideration and come to a different finding. Accordingly, for the above reason, leave to appeal is granted to the Supreme Court of Appeal, and that cost will be cost in the appeal. Court adjourns. You are all excused.
So, Masego, we also just heard before the judge there from the counsel for the Correctional Services, and they obviously had agreed with what Advocate Dalimpofu had put forward.
That's right, Rupiu. I remember they were coming in as, the department that did give authorization for the former president to go home after serving such a short time in prison of his 15-month jail term for contempt of court. So Advocate Mpatlele, they're basically telling the court, particularly the judge, saying that, with all due respect, Judge, you made this decision without even looking at some of the documents that we were given by former President Jacob Zuma's doctors and nurses who were there either at Correctional Services or even before he came into our care. You didn't consider any of that. All you considered was the actual application that was filled out by Dr. Mafa, but you did not ask for any further, documents that would prove his, claim that he's terminally ill. So that's what you heard there from Advocate Mpatlele, who was in court on behalf of the Department of Correctional Services.
Masego, thank you very much for combing through the judgment that was delivered today. Of course, she'll continue to bring you those developments throughout the afternoon.